I'd like to begin by acknowledging that we're meeting here on the lands of the Wurundjeri people of the Kulin Nations, and we pay respects to elders past, present, and emerging. It's particularly fitting to acknowledge the traditional custodians of this land, given that there were concepts within that culture that still live, relating to the protection of the climate system, relating to the protection of the atmosphere, the biosphere, the geosphere, etc. And so we are acknowledging the place of this living culture amongst us. My name is Margaret Young. I'm a professor here at the law school and director of the Institute of International Law and the Humanities, the institute that is delighted to be hosting this talk today. It is giving me great pleasure to welcome our visitor, Professor Dr. Angela Schwerdtfeger, who hails from or is a chair of public law at Freie University Berlin, and has spent many years in Germany in various posts, but also has been a visitor at various places. We're delighted that she's visiting IILAH for the month of March. She was destined to be here a bit longer, but the current situation with airlines has delayed her start, but we're very happy to have her here, and so she can be contacted by IILAH if you have follow-up questions. As you've noted, she's going to be talking about climate protection as a driver for the development of new legal concepts in the context of jurisprudence of Europe. And this jurisprudence is flowing into Australian jurisprudence at the international level. Regional courts are taking note that it's a very dynamic and growing area of law, and it is part of other law as well. In fact, can one even disconnect climate from other areas of law these days? So we'll be, I think, left with some really important reflections today. Please join me in welcoming Angela. Thank you.
Thank you, Margaret, for the kind introduction, and thank you all for being here. It's a great pleasure for me to present and to discuss with you two successful examples of human rights-based climate litigation from Europe. So I will introduce to you two decisions. The first one is the German Federal Constitutional Court and the famous climate change order of the 24th of March 2021. So it's just a little bit old, but still very famous and important. And the second one is the European Court of Human Rights Klimasenioren judgment of April 2024. These two decisions were the first decisions of these two courts finding human rights violations due to inadequate climate protection measures by states. I will first tell you something about the common ground of these decisions and of the courts. So it is established case law in both courts that fundamental or human rights protect against impairments caused by environmental pollution. So there's a duty of protection. In German, we talk about the Schutzpflicht, and in international human rights law, you talk about the positive obligation. What was new in both of the decisions is that they added a new dimension to this, and both courts stated that this protection includes also the protection against the risks of climate change. And I will give you a very quick, short overview about on the two cases, and then we will dive deeper into the details. So first, the German case that was based on different constitutional complaints of especially young individuals. Most of them came from Germany, but there were also complaints from Bangladesh and Nepal. And there were also environmental associations filing these complaints. In the case before the European Court of Human Rights, the applications came from elderlies with women with climate change-related health problems and an association representing these women. So it's called Klimasenioren Schweiz. And the subject matter in the German case was a specific statute. It was the German Federal Climate Change Act in its first version, so from 2019. Whereas in the other case before the European Court of Human Rights, the subject matter was more general. It was the failure of Switzerland to adopt an adequate legislative and administrative framework. The argument brought before the courts was in both cases that there were insufficient measures to reduce carbon dioxide emissions and to limit global warming. What's quite interesting, I've already told you that in both cases, the complainants and applicants were successful, but the solutions of the courts were quite different. So just a short overview on that, and we will go into detail afterwards. Still on the procedural level, so at the stage of admissibility to the court, we had different ways chosen by the courts. So the German Federal Constitutional Court accepted standing of the individual complainants, whereas the European Court of Human Rights refused standing to the individual applicants. On the other side, in the German court, there was no standing granted to the associations, whereas in the European Court of Human Rights, and this is one of the new concepts I want to introduce to you, is that there was granted standing to associations as a procedural right, not like granting a fundamental right to go to court, but just a procedural right, locus standi, for the association. So this is the procedural level, but there are also differences on the merits. So on the level of the substantive rights, fundamental rights and human rights. In the German court, there was no violation found of the duty of protection, which I just talked. In the other case, in the European Court of Human Rights, there was a violation of the positive obligations with regard to climate change. And so at this point, the German court developed another new concept, and it is called the intertemporal guarantee of freedom, which is not a positive obligation, but which is a negative obligation. So meaning protection from state interference, but we will have a closer look onto that later on. And in consequence, in the German case, the rights that are violated, or would have been violated, were potentially all fundamental rights you can think of, causing carbon dioxide emissions. Whereas in the other case, we had just one right being examined closely. There was another one which concerned access to justice, but with regard to the consequences of climate change, it was the right to private and family life, so Article 8 of the European Convention on Human Rights. So this is just a short overview, and now we want to go into detail. So I will present to you the two decisions and especially introduce the new legal concepts, and then have another look at the potential of these concepts for their future application and also their transfer to other areas of law. Then I will shortly compare both and talk about some consequences of these concepts. So let me start with the German Federal Constitutional Court and its climate change order of 2021. I will start with the findings, though I think it's in an isolated way, it's hard to understand, but we will go into detail later. So the provisions of the German Federal Climate Change Act 2019 governing national climate targets and the annual emissions allowed until 2030 were incompatible with fundamental rights insofar as they lacked sufficient specifications for further emission reductions from 2031 onwards. The starting point in this decision was also looking at the right to protection, so the fundamental right to the protection of life and health and the fundamental right to property. And as I stated, the court acknowledged that this encompasses also the protection against the risks of climate change. But there is a huge problem in this regard, because according to the established case law of the court, the German Federal Constitutional Court, if you have a look at the right to protection, so not the defensive right against state interference, so the positive obligation equivalent, there is a very wide margin of appreciation and evaluation of the legislator. And in this case, the court stated that the legislator had acted, so it had enacted the Climate Change Act 2019, and that was sufficient for fulfilling this positive obligation, or at least no violation of duties of protection could be ascertained because of this very wide margin of appreciation. And this was the reason why the court, to come to the result that these constitutional complaints were successful, it had to develop a new concept. And this is the concept of intertemporal guarantee of freedom. I will first show you a quote from the order, which is the basic statement, and then we will have a closer look on what that means in detail. So, under certain conditions, and this is already very important for the further question on transferability to other areas of law. So under certain conditions, the basic law imposes an obligation to safeguard fundamental freedom over time and to spread the opportunities associated with freedom proportionately across generations. In their subjective dimension, fundamental rights, as intertemporal guarantees of freedom, afford protection against the greenhouse gas reduction burdens imposed by Article 20A of the Basic Law, so our Constitution, being unilaterally offloaded onto the future. And according to the court, the Climate Change Act 2019 gave rise to risks of serious, disproportionate burdens on future freedoms. That is, risks of future impairments of fundamental rights. So that's why the court found that the Climate Change Act 2019 was partly unconstitutional. Before I come to the argument of the court, I want to elaborate a little bit on the basis of the argument, which was elaborated by the court in 3 steps. So at the first step of the basis, there's this Article 20A of the Basic Law, so of our Constitution. And it reads as follows: mindful also of its responsibility towards future generations, the state shall protect the natural foundations of life and animals by legislation and in accordance with law and justice, by executive and judicial action, all within the framework of the constitutional order. And from this is taken an obligation of the state to take climate action. It's not a subjective right coming from this provision. It's more, so in German we call it Staatszielbestimmung, so it's a fundamental national objective. The second step is that the legislature, the German legislature, with the Federal Climate Change Act, has specified the climate goal flowing from Article 20A of the Constitution in a constitutionally permissible manner, limiting the increase in the global average temperature to well below 2 degrees Celsius and preferably to 1.5 degrees Celsius above pre-industrial levels. So this temperature goal from the Paris Agreement was introduced into the Federal Climate Change Act in its first section. And so the Federal Constitutional Court decided that this is now the relevant standard under German constitutional law. And the third step, which is quite important for the new concept the court developed, is that the temperature limit can in principle be converted into a corresponding global carbon dioxide emission budget, which can then be allocated to states. So the court referred to the global budget that was calculated by the IPCC, and then also referred to a national budget that was calculated on the basis of the global budget by the advisory body, the German advisory body on environmental matters, which took a per capita approach. So you can argue if this is the right one, but this was the one underlying the decision of the German Constitutional Court. So we come now to the argument with this basis of this carbon budget, also the national carbon budget. The court stated that the Federal Climate Change Act 2019 allowed overly generous amounts of greenhouse gas emissions until the year 2030. So taking into consideration the national budget and looking at the provisions of the Climate Change Act, the court said that in the year 2030, the budget would almost be completely exhausted or even completely exhausted. And for the national climate target to be reached, the reduction still necessary after 2030 would have had to be achieved with ever greater speed and urgency because of this situation, the carbon budget already being almost exhausted. And so it was called, or they talked about, and also the complainants already said, this would mean that there has to be an emergency stop. So from one day to another, you should stop with all the emissions, and so each activity that you do should almost be prohibited to come to this climate neutrality, which is needed when the budget is already exhausted. So future obligations to reduce emissions would have had an impact on practically every type of freedom, and that is because virtually all aspects of human life still involve the emission of greenhouse gases. So in any case, there would be protection through the general freedom of action as the elementary fundamental right to freedom. So whether it's traffic, whether it's building, whether it's food, everything has to do with emissions. So all these freedoms would be concerned. So the legislator, in the view of the court, should have taken precautionary steps to mitigate these major burdens in order to safeguard the freedom guaranteed by fundamental rights. And one specific point was that there was a lack of a legal framework specifying the minimum reduction requirements after 2030. Because according to the court, there was a necessity to initiate the transition to climate neutrality in good time and not only starting in 2030, because then it would be too late. So it was necessary to provide orientation for the required development and implementation processes and conveying a sufficient degree of development urgency and planning certainty. So that, for example, the industry can develop new techniques so that electric cars and so on can be developed, and so that that there's not this emergency stop, that we can just have a slow transition into climate neutrality. And in this context, the court also talks about the eingriffsähnliche Vorwirkung, and it seems to be something like the advanced interference-like effect of the Climate Change Act 2019 on future freedoms, which means that the amounts of the carbon dioxide emissions that are allowed until 2030 play already a role in determining future restrictions on fundamental rights de jure. So what we do today or what we're not doing today will influence what has to be done in the future. So this is the new legal concept in brief, and I will now have a closer look onto the limits of this concept. We have had several decisions of the Federal Constitutional Courts afterwards, and I want to present to you very shortly two of them because they concern the limits of this approach. There was one order in January 2022 which dealt with constitutional complaints on climate change legislation of the German states, so of the Bundesländer. We are a federal state, so the original decision was on the federal level, on the Federal Climate Change Act, and now the complainants tried to fight also against the insufficient legislation of the states, or also the lacking legislation of the states. But in this case, the court said that this concept of intertemporal guarantee of freedom doesn't work. Why? Because there is no specific carbon dioxide budget of the German states. It still works on the federal level to have a national budget, but as there's no fixed proportion how to share it between the Bundesländer, it doesn't work to have a fixed budget with which you can work and have this concept applied. So the constitutional complaints were inadmissible in the view of the court. And then there was another order of December 2022, which concerned constitutional complaints on lacking speed limits. So there were persons and associations trying to force the legislator to introduce a speed limit, which is a quite controversial matter in Germany, the country of fast driving cars and so on. So they said we have to do that now because otherwise in the future we have to take much more severe measures. But also in this case, they were not successful. So the court stated that the constitutional complaints must address the totality of permitted emissions, only the totality of emissions and not specific actions or emissions by the state could disproportionately shift the burden of reduction to the future, because there's always a possibility to compensate and do something else to save the emissions. So also in this case, the constitutional complaints were found inadmissible. And I will now come to the potential for future applications, so the transfer to other areas of law. That has been discussed a lot after the first of the first order I presented to you. And it was discussed for different areas of law. So, for example, for special areas of environmental law, for the social security systems, for tax law, for budgetary law, for the pandemic policy, which was at that time. And there were also suggestions to take a comprehensive perspective across legal areas to have, this intergenerational justice thinking introduced into other areas of law. And now we come back to the quotation of the climate change order, where the court stated that only under certain conditions the basic law imposes an obligation to safeguard fundamental freedom over time. And if you have a closer look on the order, you can see that there are two characteristics, two criteria that the court points out that are very specific for climate change and that limit the transfer to other areas of law. The first is that the impacts of the carbon dioxide emissions on the Earth temperature are largely irreversible. So it's not enough that there's just financial loss or something like that, but there has to be something which is really irreversible. So, for example, if you think at the crossing of tipping points in the matter of climate change. And the other point is that with regard to climate change, you have these constitutional obligations to take climate actions. So you have the duties of protection arising from fundamental rights, as I introduced to you, although there is still a margin of appreciation, but that might be different in 2030, for example. And you have the objective obligation under Article 20A of the Basic Law of the German Constitution. Okay, and then there already have been constitutional complaints trying to transfer this concept to other areas of law. And there's a quite recent decision from, I think, January or February of this year, where a constitutional complaint on statutory pension insurance was not admitted. So the social security system, where they tried to transfer this argumentation, and the court stated that that was unsubstantiated. And there's another constitutional complaint that tries to transfer this argumentation to biodiversity. And this constitutional complaint is still pending before the German Federal Constitutional Court. Okay, this was the German Federal Constitutional Court. So I will now come to the European Court of Human Rights, to the completely different decision in the Klimasenioren judgment of 2024. I start with the findings also in this decision. The court found that Switzerland failed to comply with its positive obligation under the European Convention of Human Rights to adopt a satisfactory regulatory framework to combat climate change. And the starting point here as well is that the right to private and family life, so Article 8 of the Convention, encompasses a right for individuals to effective protection by the state authorities from the serious adverse effects of climate change on their lives, health, well-being, and quality of life. So Article 8 is also the article which is often used in the environmental law context. Even at the first glance, it doesn't look so close to it, to health and so on, but it's established case law. The problem here now was the necessary victim status of the applicants, because we have one provision in the European Convention on Human Rights concerning admissibility to the court, and that reads as follows. The court may receive applications from any person, non-governmental organization, or group of individuals claiming to be the victim of a violation by one of the high contracting parties of the rights set forth in the convention or the protocols thereto. So you see here that also non-governmental organizations are mentioned, but they always have to be a victim of a violation by themselves, so individually. The European Court of Human Rights said that there has to be an especially high threshold for fulfilling the victim status criteria in the climate change context. And this is to avoid actio popularis, because the number of persons affected by climate change is indefinite. So they didn't want to open up the door for everybody to go to court with regard to climate change. So we developed two conditions in the context of climate change, which are that there has to be a high intensity of exposure of the applicant to the adverse effects of climate change, and a pressing need to ensure the applicant's individual protection. And these criteria were not fulfilled by the individual applicants. So you remember our elderly women, so the Klimaseniorinnen, the elderlies with women that were complaining about health issues because of climate change. Also, the application, also the association cannot, according to the court itself, claim to be the victim of a violation of the convention. And this is what normally was the criteria for being granted access to the court, so the victim status. And this is now where the new concept comes into play. So the court, the European Court of Human Rights, developed an altruistic collective human rights action. According to the court, the applicant association, Klimasenioren Schweiz, which represented the interests of these elderly women, has standing to act on behalf of its members. And this is just locus standi, as I said. It's no substantive right, but it's a pure procedural position. So it's standing of associations as representatives of the individuals whose rights are or will allegedly be affected. It's an altruistic human rights application for associations, which is not provided for in the European Convention of Human Rights. You've seen the provision of Article 34 demanding victim status. So this is an unwritten exception of this victim status criteria. What's the argument for granting standing to environmental organizations? Its first reason is the complexity of the global phenomenon of climate change, according to the court. It states that recourse to collective bodies is sometimes the only means for citizens that are confronted with particularly complex administrative decisions to defend their interests. So first reason, complexity. The second reason is that the adverse effects of climate change are not the concern of any one particular individual or group of individuals, but are rather a common concern of humankind. And the third reason is that in the climate change context, intergenerational burden sharing is of particular importance. So the defense of convention rights for those at a distinct representational disadvantage necessitates this standing of associations. And the court further supported its argumentation by referring to other international instruments. Above all, it refers to the Aarhus Convention, and it said that all the observations, so the three reasons I've told you, they are all reflected in the Aarhus Convention, for example. The Aarhus Convention is an international treaty that was negotiated within the framework of the United Nations Economic Commission for Europe. and it deals with access on information, on participation in decision-making, and on access to justice in environmental matters. But one has to say that this convention only provides these procedural rights to protect the right to a healthy environment, which itself is not enforceable as a substantive right according to the convention. So this is something that, yeah, makes this argument a little bit weak. Then the court also stated that there are certain conditions for an association to go to court to represent its members or other vulnerable persons. It says that the association in question must be lawfully established. It must pursue a dedicated purpose in the defense of the human rights of its members or other affected individuals, and it must be regarded as genuinely qualified and representative to act on behalf of its members. And these conditions don't come from the convention, but they come from the Aarhus Convention, so the international treaty to which the court referred. And what is quite remarkable is that there's no requirement of showing that those on whose behalf the case has been brought would themselves have met the victim status requirement for individuals in the climate change context, which was not the case also in this case, because the elderly women were denied access because of their missing or lacking victim status. So what is the potential for future application or transfer to other areas of law? So there was another decision in February 2025 dealing with environmental matters. It was the case of Cannavacciolo versus Italy, and it dealt with the systematic, decade-long, widespread and large-scale pollution phenomenon caused by illegal dumping, burying, and or uncontrolled abandonment of hazardous special and urban waste. So the danger to health due to exposure to the environmental pollution. So there's a certain area close to Naples in Italy, which is also called Terra dei Fuochi, or the land of fires, because they're burning all the waste and so on. And this was brought to the European Court of Human Rights. And there have also been associations filing applications to the court, and they refer to the Klimasenioren judgment. And that's why the court, in this case, stated that the recognition of standing of associations in Klimasenioren was justified by specific considerations relating to climate change and the special feature of climate change as a common concern of humankind and the necessity of promoting intergenerational burden sharing in this context. So you see the reasoning from beforehand. And it said that this recognition is limited to this specific context. So in this case, there are no other special considerations or exceptional circumstances. So in the end, there was no standing granted for the associations. So it limited this concept of these altruistic collective human rights action closely to climate change and not to other environmental law areas. So we will now compare these decisions again a little bit more in detail. So I will also talk a little bit about the consequences of these different pathways to reaching the goal of finding a violation of human rights. And I will start again with a slide from the beginning, but which is now a little bit more in context, I guess. So if we look at the standing requirements, so on the level of admissibility, we've seen that there was standing of individual complainants before the German Federal Constitutional Court. There was no standing of individual applicants before the European Court of Human Rights. And was the other way around with regard to associations. So the German court denied access to justice for associations, but the European Court of Human Rights granted standing of associations, and that was particularly this new concept that the court developed. If we have a look at the merits and at the level of the substantive rights, there was no violation of a duty of protection before the German court. On the other side, before the European Court of Human Rights, there was a violation of positive obligations. And this was where the new German concept of intertemporal guarantees came into the game and was developed as a kind of a new dimension of negative obligations of fundamental rights. And we've seen that the rights violated in the German case because it concerned all future activities still causing emissions. It included potentially all fundamental rights, whereas in the European Court of Human Rights case, with the positive obligations, it was precisely the right to private and family life. So let's have a closer look on standing first. I want to show you another quotation from the German court, which is quite interesting in comparison to the Klimasenioren judgment of the European Court of Human Rights, because the German court states that the mere fact that very large numbers of people are affected does not exclude persons from being individually affected in their own fundamental rights. So there is no requirement that complainants are especially affected beyond simply being individually affected in some particular manner that differentiates them from all other persons. And in this context, the court states also that this is unlike the case law of the European Court of Justice. So not the European Court of Human Rights, but the European Court of Justice in Luxembourg, who also decided in a famous case called Carvalho that there was no access for individuals to go before the court in an action of annulment procedure against EU legislation on climate change. On the other side, there was no standing of environmental associations as advocates of nature, which was brought forward by the associations, because there was no provision in the basic law or constitutional procedural law. It was the other way around. We've seen that in the European Court of Human Rights. So the court said that there's a especially high threshold for fulfilling the victim status criteria in the climate change context to avoid actio popularis, as the number of persons affected is indefinite. And the criticism against this is that granting locus standi to associations is de facto an admission of actio popularis. This was the standing, and so we'll now have a closer look at substantive rights and the consequences of these different concepts. So we've seen that there was no violation of the duty of protection found before the German Federal Constitutional Court, but there was a violation of the intertemporal guarantees of freedom, so this negative obligation, protection against state interference. And so what was discussed a lot afterwards, and which was also criticized, is that this concept shifts the focus on predetermined future state measures, and these state measures are climate protection measures. So here the violation results from climate protection, and this was criticized a lot because it's the omission now that leads to climate protection measures in the future, and they will cause the human rights violation. And there was a huge discussion that this should have been the classical situation of positive obligations and not of this kind of defensive right against state interference, which was used in this construction of the German Federal Constitutional Court. Another consequence is that there was no standing for complainants living in Bangladesh and Nepal. Why? Because they will not be exposed to future German climate action measures, because the German measures will only be taken on German territory because of state sovereignty. And so it doesn't concern people outside of Germany. It's not like that for the duty of protection. The duty of protection can also protect people abroad, not with the same content of the right as the Federal Constitutional Court says, but for example, mitigation measures in Germany can also be positive for people abroad, whereas adaptation measures, so the second pillar in the climate change context, cannot be of benefit for those people abroad because it's against state sovereignty measures only on its own territory. If we come to the violation of positive obligations by the European Court of Human Rights, there was, as we've seen, no victim status. So an individual violation was not necessary. So the consequence was that there was just a general assessment of state obligations. And this leads to the question whether this means a lowering of the threshold to find a violation. But because if you don't need an individual violation, but in the end you say there is a violation, that might be a lowering of the standards for acknowledging a violation of human rights standards. So I come to the conclusion. First, the result of the decisions, the two very different decisions as we've seen. Both courts found violations of fundamental rights by states due to insufficient climate protection measures. Concerning the path chosen by the courts, the legal concepts developed offer very different perspective on procedural law, but also on human rights protection. The German Federal Constitutional Court found a very complex doctrinal reasoning to reach this result, whereas the European Court of Human Rights reasoning was strongly based on considerations of necessity and fairness, complexity, burden sharing, intergenerational justice, and so on. And to the scope of the convention, one can say that the legal concepts developed on both sides are likely to remain applicable only to climate change. Thank you very much for your kind attention.